All right, good morning, happy Monday. Local government will come to order. Clerk, call the roll.
You have a quorum, Mr. Chair.
And online quorum as well with Senator Rome. Thank you. All right, first up, a couple items of business. Senator Salim, you wanted Senate Bill 304 also carried over. I don't think it's on our docket anymore. We'll hear that next week. Two other bills on our docket, Senate Bill 544 and Senate Bill 645 have been requested to be carried over till next week. Is there a motion? There's a motion and a second. And I hear an addition and amendment of 430. Senate Bill 430 also going by for the week. All in favor, say aye. 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 All opposed? We'll hear those next week. Thank you, Senator Rome. All right, first up, Senator Locke, Senate Bill 90. We had this in queue for next week, so please present your bill.
Thank you, Mr. Chair and members of the committee. Senate Bill 90 deals with the Fort Monroe Authority, addressing a portion of the code that addresses the Fort Monroe Authority Act that describes and ratifies the Commonwealth's ownership and responsibility for certain lands and utility infrastructure on the peninsula on which Fort Monroe is located. Paragraph A describes only the portion of the Fort Monroe Peninsula that is owned by the Commonwealth. Paragraph B describes the entirety of the Fort Monroe Peninsula, portions of which are owned by the Commonwealth, the National Park Service, and the United States Army. Paragraph B further provides that the Commonwealth owns and has certain maintenance obligations for roads, water, sewer, and other utility infrastructure located on the entirety of the peninsula. Paragraph A is no longer an accurate description of the portions of the peninsula owned by the Commonwealth on account of a combination of in-conveyances and out-conveyances that have occurred since the enactment of this section. This bill proposes to revise paragraph A so that the description of the land owned by the Commonwealth is currently accurate. This proposed text is also drafted so that paragraph A will not need to be amended again based on future acquisitions or dispositions by the Commonwealth or portions of land on the Fort Monroe Peninsula, so that we don't have to keep coming back changing this over and over again. That's what it does.
Thank you, Senator Locke. And I guess as a question for council real quick, I think one of the members of the committee had a question on just line 22. The version we have before us has an end parent, a future reference to a deed. What is the net effect of having that, or is there an amendment to that?
Sorry.
On lines 22, it's a question for council. I guess the version that we have, unless there's an amendment or substitute, still has sort of an end parent new deed reference to be determined once a deed of consolidation is recorded. What is the net effect of the language as currently reading?
Mr. Chair, I guess the net effect would be that someone wanting to know that description is going to have to go to the courthouse to see where it's filed and read it there. If I understand your question.
Okay. Any follow-up questions from the committee? Senator Sturtevant.
Just a follow-up question for council. Can we vote on it if it doesn't have the actual operative language in there yet? Because the deed hasn't been recorded?
Mr. Chair, I'm not sure how to address the issue of it not actually being prepared as yet and recorded as yet. The fact that it's a reference to something in the courthouse is not unusual. We see that with local government charters and boundaries and so forth. But I'm not quite sure how to answer that first question.
Phone a friend.
Welcome. State your name and how you can assist with a friend.
Glenn Oder, I'm the Executive Director of the Fort Monroe Authority, a longtime friend of Senator Locke, and I hold her in great esteem, and I appreciate her bringing this bill before the committee. I want to say the challenge for Fort Monroe is it's a coastal island in the Chesapeake Bay. Basically, it's 565 acres of land, 2 million square feet of buildings, and 1 water meter for the entire
Mr. Hiller,
property.
can you speak to the question?
Yeah, I will.
You're in support of it, obviously, and so can you speak to the question before the committee?
Yeah, the issue is the property keeps changing because of coastal, because it's a coastal piece of property. That means the survey would change. Also, too, there are things such as the lighthouse is getting ready to transfer back to the Commonwealth of Virginia. That's a small 50 by 50 piece of property. So the property is going to continue to change. And so what the Attorney General's office was doing was trying to draft this so that it could go before we would not have to come back here every year. And so, yes, the issue would be going to the courthouse to identify the exact acreage of land and so forth.
Thank you. Any follow-up questions? All right, the bill's before the committee. Is there a motion to report? Second. There's a motion is second. All in favor, cast your votes aye. Those opposed, no.
Senator Rome, how do you vote?
All right, that
Ayes
bill.
15, no 0.
Thank you. That bill reports 15-0.
Thank you, Mr. Chairman, members of the committee.
Thank you, Senator Locke. Senator Salim, you have Senate Bill 316 that was also on last week's docket.
Thank you, Mr. Chairman, and thank you to the committee. I'm here to talk about Senate Bill 316, which allows the town of Vienna by ordinance to require that a subdivision or development provide for the preservation or replacement of trees on the development site, such as the minimum tree canopy 10 years after the development is projected to meet specified coverage criteria. Under the current law, the criteria applies to tree canopy coverage for 20 years after development. So this does not significantly change. The only thing this does is that it allows the town of Vienna to go from 20 years to 10 years, essentially going back. And some of the reasons that they want to be able to do that is the overdevelopment and the development of the town of Vienna that's happening. They want to be able to catch up to that, along with the fact that Fairfax County, the city of Falls Church, the surrounding counties currently are on the 10-year requirement. And of course, being surrounded by those cities and towns, the town of Vienna would like to include that option as part of their adoption. And of course, this is an optional provision in the state code and is not mandatory. It only permits the affected localities to adopt the requirement if they choose to. So they are simply asking to go back to 10 years. And we do have somebody who would also like to testify. And there was a letter that was circulated, if you have gotten it, from a council member who sits on city council for the town of Vienna.
Thank you, Senator. Any questions on Senate Bill 316?
Mr. Chairman.
Senator Servon.
Mr. Chairman, Senator Salim, this is a permissive, it's just allowing Vienna, should they choose to.
Correct.
Okay.
Thanks.
And it's reducing, as I understand it, would be a requirement that there be more mature trees sooner than otherwise?
Correct. So right now, if you look at, Williamsburg, Chesapeake Bay, all the way down to other towns and cities, they have changed that requirement from 20 years to 10 years. This is just allowing them, given that the amount of development that's taking place, the developers would have the town would have the ability to tell the developers they need to replant some of the trees so that they get back to that same number within 10 years rather than 20 years.
Thank you.
Senator Drunt. Okay. Any other questions of the committee? You have a speaker here as well?
Yes, I do.
In support? Please approach the mic, state your name, and if you're with an organization, and we have a lot of bills this morning, so appreciate hearing from you.
Good morning. My name is Mariam Datka. I'm a town of Vienna resident. I do a lot of restoration, habitat restoration, and trying to preserve the trees that we have in town of Vienna. Right now, we're fighting with invasive species, with deer, and also developers and other problems that we have with getting rid of the tree canopy. We went down 13%. overall in town of Vienna over the 10 years assessment, and in some areas 30%. In the state of Virginia, it's 18%. So we are trying to preserve as many trees as we can in town of Vienna, and we need your help to basically to go to what Fairfax County has to preserve the trees from the 20% canopy coverage in 10 years instead of 20 years that we do have it. So we would like to see that 10 years to happen also in town of Vienna. We already have it in Fairfax County. We just want it to be enforced in town of Vienna as well.
Thank you so much.
Thank you very much for
Thank you
having
for coming down and providing your thoughts this morning. We have one speaker online as well in support.
Yes, sir. Scott Cameron, you may now unmute and speak.
Good morning, Mr. Chairman. My name is Scott Cameron. I'm Vice Chairman of the Northern Virginia Soil and Water Conservation District and Chairman of its Legislative Committee. The mission of the district is to promote sustainable urban and suburban activities and stewardship to conserve our soil, water, plants, and animal resources in Fairfax County. We serve the county's 1.2 million residents. Trees are a valuable natural resource that provide wildlife habitats, department facilitates stormwater management, beautify neighborhoods, and reduce urban and suburban heat islands that reduce residential and commercial utility costs. As a result, anything that the General Assembly can do to encourage.
Sir, can you pause just for a moment? We're trying to get your audio to come in a little clearer, if possible.
Also, if you could speak closer to your microphone, please. Thank you.
Okay. Is this any better? Can you hear me better now?
It's still very faint. Possibly if you have a headset.
Unfortunately, I do not have headsets. Can you hear me better now?
Okay, sir, yeah, we apologize. We can see you on screen, so we get a big thumbs up if you're in support. That'll help us out this morning. All right, thank you so much. Is there any opposition to Senate Bill 316? All right, seeing none, is there a motion? There's a motion, a second to report. All in favor, say aye. Cast your ballots, aye. Those opposed, nay.
Senator Rome, how do you vote?
Cast, say what you.
Ayes 13, noes 2.
Ayes 13, noes 2. The bill reports. Next up,
Thank you, Mr. Chairman.
Senator Head. You bring us and bless us with 4 bills this morning. Is that correct?
Thank you, Mr. Chairman. We can start with Senate Bill 134.
All right, Senate Bill 134. Go ahead, Senator.
Yes, sir. This bill seeks to just allow the Board of Supervisors of Craig County to appoint one of its members to the Economic Development Authority of the County of Craig. It's such a small county with a very, very rural population, less than 5,000 people, and so they have a hard time finding members in there already. One of the members of that board was just recently elected to the Board of Supervisors and had to come off the board, and they are having trouble finding someone else to fill the slot. And there was already provision for this, as you'll see, with Matthews County, and this just adds Craig County to the list. So, pretty straightforward bill.
Any questions of the patron? Any opposition to Senate Bill 134?
Move to report. Second.
All right, there's a motion and a second to report. All of those in favor, cast your electronic vote.
Senator Rome, how do you vote?
I can name the one person I probably should be voting for.
Ayes 14, no 0, 1 abstention.
Ayes 14, no 0, 1 abstention. The bill reports. Next up, Senate Bill 135.
135, yes. Mr. Chair, this is the bill we attempted to begin last week at the meeting and needed to bring this back to you as an amendment in the nature of a substitute. What this does is addresses the issue of site development for areas that are receiving or are eligible to receive grants from the Virginia Economic Development Partnership Authority. Currently, the
Senator Head, we have the substitute before us.
Yes, Mr. Chair, we
Move
do
the
have.
substitute. Second.
There's a motion and a second to adopt the substitute. All in favor, say aye. Those opposed? Motion carries.
And,
Substitute is before us.
Thank you, Mr. Chair. And the changes from the introduced bill, you'll see on lines 19 through 29. There's some new language that you'll see there, just giving some clarification as to what needs to be required to lower the size of the eligible sites from 100 down to 50 acres. This does give a great opportunity for some of our areas that have topographical challenges, and finding large sites become really a problem. But again, fairly straightforward bill. I think there had been some support for this in the past, but this just gives some further clarity to that.
Any questions for the patron? All right. Any opposition?
Mr. Chairman,
Anybody care this morning? Support?
I care.
All right. Senator Suderline, there we go. We got some action.
I think this is important for those of us with lots of beautiful mountains near us that are hard to develop on. I move that we report Senate Bill 135.
Slow it up. This one's going to finance. There's also relative budget amendments associated with this, and budget language, and lots of other things that Senator Head wants to have these applied to all parts of Virginia, so it's got a little trip to do first. So is that a revised motion?
Sure.
There we go.
Second.
It's motion to report and re-refer to finance. All in favor, cast your votes aye on the electronic ballot or nay.
Senator Rome, how do you vote?
I'm a yes. There it goes.
Ayes 15, no 0.
All right, Senator, enjoy the trip to finance. Next up is Senate Bill 136.
136. Yes, Mr. Chair, this was brought to me by an organization in the district. It's a request to just limit the opportunity for a governing body that gives financial contributions and support to a nonprofit organization if they are then appointing membership to that board of directors, that it would just say that you can appoint anybody you want to, except for the spouse, child, stepchild, parent, step-parent, or grandparent of the members of the governing body of that locality that would be sending that information there. Again, fairly straightforward. We'll just operate at your pleasure.
Any questions on Senate Bill 136? Senator Williams-Graves.
Thank you. So is it prohibiting the prohibition of appointing people related to the localities board to a nonprofit? Like if I'm married to someone and I'm on the locality board, I can't appoint my husband to any board or just a nonprofit board?
To any nonprofit board that receives funding from the locality.
Gotcha. Thank you.
That's the only prohibition is that if there's money going along, you can't put your spouse on that board or your family member on that board.
Any other questions from the committee? I do have one, Senator. So we just passed a bill allowing sort of a transition of appointments where we have localities that actually have a hard time sometimes of getting folks to serve on boards and commissions. This committee just approved one exemption to that. So we're fixing one problem and causing potentially another. And I know a lot of small towns, and I've got 2 towns, one of which does have a hard time within my district. And so I have a pause at.
I can,
fixing one thing and then causing another, because a lot of times our local small towns use our nonprofits to do a lot of good work, whether it's healthcare service. You know, if I was in Abington and had dental and maybe some other things, and I had a mayor that was my spouse, for instance, just a hypothetical. And I also served in providing dental care, and I therefore couldn't serve on that board, yet I might have absolute beneficial contribution to the community.
Mr. Chair, I think that you perhaps bring up some very valid points, and we'll leave that with the committee to determine what you want to do with this.
I appreciate it. Any follow-up questions from the committee?
I'd like to take it 5. You're good with that. Mr. Chairman.
Senator Sturtevant. I'm sorry, Suderline.
You know, I'm not. I'll refrain from my comment today. I don't mind being confused for him appearance-wise, but I would suggest that maybe we should take this by for the year, if that's agreeable to the patron, or at least by for some time. How much time would you think you would like?
Again, I will operate at as we all do for all bills, operate at the pleasure of the committee.
Do you want by for the week or by for the year?
This one seems like it's going to take a trip for the Senator Rome.
Mr. Chairman, I have a question for the patron, if you could be able to clarify for that.
Proceed. You're a little hard to hear, unfortunately, but.
Mr. Chairman, when I read the actual bill, it seems to go beyond the scope of what the patron said. On lines 13 and 16 says, notwithstanding any other provision of law, general, or special, no local governing body shall appoint spouse, child, stepchild, parent, step-parent, or guardian of a
How many words?
as a member of any local government board.
That's why you don't allow.
Or as a member of a.
All right, Senator Rome, we're having a difficulty hearing you. My apologies.
Okay. So,
Do you want to move to carry it over?
Chairman, I think that best, I'd like to move that we carry this over to the 2025 session.
All right, there's a motion and there's a second. All those in favor of continuing, please cast your votes, ayes, nays, etc., on the electronic board.
Senator Rome, how do you vote? Ayes 12, noes 3.
All right, thank you, Senator. That bill is off until next year sometime.
Very good. Thank you, Mr. Chair. And finally, we have Senate Bill 413, and there is a fairly long amendment in the nature of a substitute for this, which comes from the Code Commission.
All right, the substitute is now available to us online. Council is working on it. Is there a motion on the substitute? There's a motion and a second to adopt the substitute. All in favor say aye. Aye. Those opposed? The substitute is properly before us.
Okay. Thank you, Mr. Chair. Senate Bill 413, with the adoption of the substitute, puts this in conformity with a companion House bill. What this is seeking to do is bring some clarity to public notices. It doesn't have anything to do with where they appear, but just simply the time frame of when localities would have to put forward certain information that's out there. The charge of the Code Commission work group on this issue that was led by Amigo Wade and consisted of the Virginia Press Association and the Virginia Municipal League and the Virginia Association of Counties, Local Government Attorneys Association, and individuals representing that, and as well as the Home Builders Association representatives, was to come up with something that would sort all of this out because there have been problems for some time. There was work that was done in 2023 and some amendments that were made that sought to achieve all the objectives that they had as that work group. But when they were put into practical application, there were some unintended consequences that came up and some unforeseen circumstances encountered by local entities. This bill brings forth the recommendations to try to alleviate that. Specifically, the changes for this are that in Group 2, it increases the time frame for appearance of first notices from 14 to 28 days prior to the meeting, with the publication of the second notice appearing no more than 7 days before the meeting or the intended action. Then in Group 3, it increases the time frame for appearance of the first notice from 21 to 35 days prior, with the first notice appearing no more than 35 days and the last notice appearing no more than 7 days before the meeting. And it also deletes all the language in the covered notices requiring subsequent notices to be published at specific times. For example, if it had said, with the second notice appearing no more than 14 days before, to try to eliminate the confusion and to establish some more uniformity. The second part of the bill also continues the work that was done last year to reduce the length of many of the notices by reducing the amount of information that was required to be contained at each notice, such as referring different parts of the code back to 15.2-2204. We changed that last year to remove the descriptive summary language, and instead it allows advertising by reference with a link to more information or where it might be available in the county planning office. So if people wanted additional information, they can get to it, but it just reduces, some of these notices get to be really, really long, and this will help reduce that down to make more people able to sort of wade through that and get access to it. Again, this does come as recommendation from the Code Commission in this form, and we do have some folks here that can speak for this a little bit more clearly.
Any questions for the patrons? 105-page substitute this fine Monday morning.
Mr. Chairman.
Because I know we've all read it all
Every
at this
word.
point.
Yeah.
Senator Sturdivant.
Mr. Chairman, Senator Head, so the original bill was very, very simple and expanded from 14 days to 45 days the length of time prior to a meeting to adopt certain planning and zoning matters that the first notice of a meeting may be published. And then, so the substitute is very, very different, it seems, and much more comprehensive, and it's not clear to me if there's more time being built in or less time, or it depends on the circumstance.
Mr. Chair, I would respond that there is more time than is currently allowed, but somewhat less time than we had proposed in the initial legislation. But again, this was the bill that we had put in was in conflict with recommendations from the Code Commission. And when they looked at the bill, then everything trying to get onto the same page so that we wouldn't be. And the other part was they were already moving through in a House bill which is basically what you have before you is the conformity of the House bill. Had we not done this, we would have had two bills moving through. And that House bill, I think, has already been referred out through and is on its way, and I don't think has had any opposition to it thus far.
Yeah.
But
Senator Head, or Mr. Chairman?
Senator Suderline.
Thank you. I would move that we carry this bill by for the week and consider it next week after we've had time to read the small novella here.
All right, there is a motion. I know there is some rather consensus around the bill, but given the light, it's a 105-page bill. We are fast readers, but not that fast. There's a motion and a second to carry this by for the week. All in favor, say aye. 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 Those opposed? See you next week.
okay, thank you, Mr. Chairman.
Next up, Senator Craig. Thank you, Senator Rome.
All right, good morning, Mr. Chairman, members of the committee. I have Senate Bill 171, which is a zoning civil penalty commercial use bill. It enhances civil penalties for zoning violations involving unpermitted commercial use. It adds to a definition for the purpose of this code section for a non-permitted commercial use. For those who waive a trial and admit liability, add a provision in the code requiring the person to abate or remedy the non-permitted commercial use violation with the period of time specified by locality that is no less than 30 days and no more than 24 months. This bill is not trying to get at the mom and pop stores and establishments. It's trying to take care of the repeat aggressive offenses. And I have someone from the city of Suffolk here if you would like to. Two amendments? Are we going to move the amendments?
Any questions from the patron?
I guess we're going to move the amendments.
We have amendments. There's a motion and a second. There's a motion and a second to adopt amendments. All in favor say aye. Aye. The bill before us is amended. You can walk us through.
Would you like?
Thank you, Mr. Chair, members of the committee. I'm Mindy Carlin. I'm speaking on behalf of the City of Suffolk. What the amendments do is they add a definition to non-permitted commercial uses because there was none in the code. That's, I think, the first one. The second one just makes it clear, as Senator Craig indicated, right now, a person who is cited for a zoning violation has the option to either go to court, in which case the court determines the period of time within which the violation must be remedied, or they can waive the trial and pay the fine. The code doesn't speak to the period of time within which they have to remedy it in those cases, and so the original bill as proposed adds that. The amendment just makes it clear that in adding that, it's not taking away any of the court's ability to set that period of time for remedying the violation. Those are the two amendments. I'm happy to speak in support of the bill as well.
Senator Hackworth.
Mr. Chair, question for the patron, please. So is this, would Airbnbs be under this?
No.
Okay, so if you had an Airbnb and it was not zoned for that, then they would not be? Okay.
Different code section, I'm being told.
Okay. What about like daycares or something like that?
Mr. Chair, I believe that would also be a different code section. No, it's under the same one?
Mr. Chair, members of the committee, Senator Hackworth, so it would apply to a non-permitted commercial use. So if you were a daycare center and you were not permitted to be a daycare center, then this would apply to you, and you repeatedly violated the zoning ordinance.
Okay.
Any follow-up from the committee? All right, is there any opposition? I'm sorry. Any opposition
We have other
to Senate Bill 171?
Thank you, Mr. Chair.
Senator Rome?
Thank you, Mr. Chair. Is my audio working for y'all now? Mr. Chair, are you able to hear me better now?
All right. Senator Rome, could you type it or text in the chat, whichever way, that it's still a little broken up audio, and our apologies.
I'll withdraw.
Okay. Senator Williams-Graves?
Thank you, Mr. Chair. I just want to say, as a former local government person, I love this bill because there are so many times that people are habitual offenders to zoning ordinances, and there lacks oftentimes teeth in the law for localities to be able to bring these people into compliance. And so thank you so much for carrying the bill. Localities everywhere should thank you.
Thank you.
All right, I'm just going to give a second for Senator Rome. Let us know if you're sending us a message still.
I thought I heard her say she supports this. I'm not sure.
Senator Rome has withdrawn her question.
All right. Is there a motion on Senate Bill 171? There's a motion to report Senate Bill 171 as amended. All in favor? Opposed and otherwise, cast your votes on electronic board.
Senator Rome, how do you vote?
Aye.
Ayes 9, noes 4, 2 abstentions.
All right, Senate Bill 171 reports with every nature of vote on the board for you, Senator Craig.
To the floor. Thank you.
All right, next up, Senator Pillion. Didn't see you there. Good morning.
This is a earth-shattering charter change bill that comes by request of the Bristol, Virginia City Council. They unanimously passed a resolution. They want to increase voter access. One of their localities is up to nearing the 4,000 voter threshold, so they want to add a voter precinct, and they also want to change the personnel department and call it the Human Resources Department, along with all the technical language updates. Mr. Chairman, that's the bill.
Any questions for the patron? Any opposition to Senate Bill 618?
Yes.
It's noted as one.
You don't like voter access?
There's a motion and a second to report Senate Bill 618 to change the lives of all within the city of Bristol. All in favor? Opposed and otherwise, cast your votes on the electronic board.
Senator Rome, how do you vote?
Thank you, Mr. Chairman, members of the committee.
Ayes 15, no 0.
Senate Bill 618 reports 15-0. I believe we've worked through our way through non-committee members' dockets. We have a couple committee. Let's see, Sue Hawes is out at the moment. We have next up Hackworth. Senate Bill 163.
Want me to report from here or go down, Mr. Chair? Here, it's fine.
Right there is fine.
Okay, thank you, Mr. Chair. So Senate Bill 163 is for the Southwest Regional Recreation Authority. It amends the code to allow the Southwest Regional Recreation Authority, also known as Spearhead Trails, to utilize procurement, Attorney General legal services, and follow the provisions of the Virginia Personnel Act. The authority has a $10 million liability policy to indemnify landowners against damages, and the services of the Attorney General's office will now be available in civil matters. It also provides the authority that may lease vehicles, construction, and forestry equipment from the Department of General Services, and then it prescribes the authority board to adopt policies for procurement of goods and the services. And I have Colonel Steve Pike here to speak on this bill and to answer any questions.
Thank you, Senator Hackworth. Any questions for the patron? And I think it looks like we have a speaker here to speak briefly, ever so briefly. It looks like this bill is going to take a trip to finance as well, if it should report out of this committee. So, Mr. Pike.
Mr. Chairman, members of the committee, my name is Steve Pike, Interim Director at Southwest Regional Recreation Authority. I've been in that role since last February. Since being there, identified some enhancements that would make our operational needs improve with the authority, and got with Senator Hackworth to request these amendments, and I would urge you all to pass this, please.
Thank you so much. Any opposition to Senate Bill 163? Senator Suderline.
Mr. Chairman, I move that we report and re-refer Senate Bill 163 to Senate.
There's a motion and a second to report and re-refer Senate Bill 163 to Finance. All in favor, cast your vote on the electronic board.
Senator Rome, how do you vote? Ayes 15, no 0.
Thank you, Mr. Chair. Then I also have Senate Bill 475, which is the Town of Pulaski Charter. It clarifies that the council's membership consists of 7 members, including the mayor, on lines 15 and 16, shifts the town's municipal elections from May to November, and permits the mayor to vote, but maintains the prohibition on veto power, and change the times of election of vice mayor from even numbered years to odd numbered years at the first meeting of the council. I have a resolution from the town of Pulaski in support of that.
Senator Suderline.
I'd like to ask Senator Hackworth a question.
Question of the patron.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to ask Senator Hackworth if there's any opposition in the community to the shift from the May to November elections.
Mr. Chair, Senator Suderline, I would answer, not that I know of.
All right, I appreciate that. I just think it's, Mr. Chairman, briefly.
Senator Suderline.
Thank you, Mr. Chairman. I just think it's important that if we're going to change the amendment or amend the charters for these, that it conform with the overwhelming consensus of the community. I know we have changed the general law, which was interesting how that was done, but I don't think we should change the charter unless there is consensus. As long as there's consensus, I'm good with it, and I'm ready to move forward when you are.
Any opposition to Senate Bill 475? There's a motion and a second to report Senate Bill 475. All in favor, opposed, or otherwise, cast your vote on the electronic board.
Senator Rome, how do you vote? Ayes 15, no 0.
Thank you, Mr.
Ayes
Chair.
15, no 0. That bill reports. All right. Next up, Senator Favola. Welcome. You've got at least two bills before the committee, Senate Bills 13 and Senate Bill 656.
Yes, sir.
Which one do you want to start with?
I think I'll start with Senate Bill 13.
All right. Committee, turn your attention to Senate Bill 13.
Thank you. Okay. This bill was actually heard in a subcommittee of Education and Health. The amendment to the bill was adopted by Education and Health and re-referred to local government. So what this bill does is it allows local governments permissive to adopt by ordinance any zoning changes they feel would be necessary to facilitate a child care center in an office building. It's all it does. It's one of those tools to help increase the capacity of child care centers. Perhaps an office building that's been vacant could benefit from this bill, but it is completely permissive, and everything would be done by ordinance if the zoning changes were to take place. That's the beginning and end of the bill. I'm happy to take any questions or.
Thank you. Thank you. Council, do we have the amendments referred to by the patron?
They're already posted.
Okay. Okay. Yeah, if we can go ahead and, if they're already adopted, I think it's in the right posture.
Right, that's right.
Any questions of the patron? Any opposition? Any brief support for those who might have, okay, got some thumbs up, and that's the thing decent enough for the committee.
I would just like to thank the senator for bringing this bill, patron this bill. This is definitely a shortage that we have, so I thank you for doing that, and very much in support of it.
Thank you, Senator.
All right, there's a motion and a second to report Senate Bill 13. All in favor, opposed, or otherwise, cast your vote on the electronic board, please.
Senator Rome, how do you vote? Ayes 15, no 0.
All right, 15-0, that bill reports. Senator Favola, you have Senate Bill 656.
Right. Thank you, Mr. Chairman. So this bill deals with a false communication to emergency personnel. And what it does is it tickles out from current law if an individual under the age of 18 makes a false communication to emergency personnel and a judge determines that it was a false communication, the fee would not exceed $2,500. However, for an individual over the age of 18, and a violation was determined by a judge, a locality could charge a flat fee of $2,500 or a minute-by-minute accounting of the actual costs. this was a request from Arlington County government. The issue here is to attempt to recover the full costs when emergency personnel are called to a school or a public facility with the false threat of a bomb. It's actually quite expensive to get all of our personnel there, and they would like the ability to actually charge a minute-by-minute accounting, and perhaps this would be a deterrent. We're not sure. That's a more complicated issue on what actually deters human behavior, but we do think it's a good bill, and I would ask for your support.
All right, questions of the patron? Senator Sturtevant.
Thank you, Mr. Chairman. Senator Favola, I completely understand the policy of doing this, and I think it makes a lot of sense. Is there a cap on how much may be charged if the locality goes the minute by minute, or is it just 100% of what they can identify as the amount of money spent by the locality the person would be on the hook for?
My understanding is there's no cap if it's a minute by minute, but I will ask General Counsel to either confirm or correct me.
Follow-up question, Mr. Chair.
Proceed.
And then my only hesitation, again, understanding the policy makes a lot of sense, is for every crime that someone is convicted of in Virginia, we don't require them to pay a minute-by-minute reimbursement of the Commonwealth for all that has gone into the investigation. And
I believe that's the actual, the way I'm reading my legislation, though, I believe current law may also permit a minute-by-minute accounting of actual costs. We're tickling out the under 18, so that's where the cap is. But current law does permit minute-by-minute.
Thank you.
Other questions of the patron? I know we have Senator Suderline.
Thank you, Mr. Chairman. I would just ask the senator, understanding that the Commonwealth has already adopted some of this policy, we as a Commonwealth and generally as a nation usually make penalties. We prefer to go down confinement or something that takes someone's time, because that's what we all have. So if we do community service, we require, or if we do the time of confinement. And when we go down the cost side, it's far more punitive to some folks than others. And I don't think anyone should be doing this, but you could also quickly see some people being wiped out immediately. If someone in their family made this poor decision, you could see a household getting wiped out fast.
Mr. Chairman, this would be at the discretion of a judge, but I would welcome an amendment on community service as an option if that is your preference. I would be fine with that and consider that a friendly amendment.
Senator Williams-Graves.
Thank you, Mr. Chair. As I understand this bill, this is related to swatting.
I'm sorry?
As I understand this bill, it is related to swatting. And swatting is just a prank. It's a crime, but it's a prank.
Mm-hmm.
And when we pull together EMS, fire, police, and sheriffs, they take a lot of time and energy responding to a prank and then possibly leaving other more serious or other situations in their wake where they're not able to respond because of the nature of these pranks. So I thank the patron for bringing the bill, and I don't necessarily support an amendment that includes community service. There are some mistakes that you just can't come back from, and to put this kind of burden on a locality and all of the other emergency personnel that are associated with this, I think the fine fits the crime.
Senator Favola, we've got a number of other bills
Sure.
to take up. I'm going to recommend, I think you've heard a couple comments for me. I think there is some interest in some language that provides some remedial
Would you like me to take it by
behavioral.
for the
So
day?
I'd recommend that we take this by for the week
Okay.
and have some tweaks to this. And I know you've got some speakers. Did you want? And I know you had some speakers online, and my apologies. We do have a number of things, and you have a speaker that also is physically in person that has come down. If you want them to acknowledge today the issue, I did want to recognize just briefly, if not, I'm okay. I just want to be mindful of those who came down in person this morning.
I mean, you're from Loudoun. I didn't realize it's had such regional impact. Just kidding. Okay. We'll take it by for the day.
All right.
I appreciate your efforts.
There's
Thank
a
you.
motion to take by Senate Bill 656 by for the day. All in favor, say aye. Aye. Those opposed? Thank you, Senator.
Thank you.
All right, next up, let's see. Williams Graves.
Thank you, Mr. Chair. And
You have Senate Bill
members
524.
Yes, Senate Bill 524. Thank you, Mr. Chair, members of the committee. Senate Bill 524 is local government installation of water-based fire protection systems in new townhouse construction. It permits a locality to allow the installation of automatic water-based fire protection systems in new townhome construction. The bill provides that such ordinance shall require that the installation be completed in compliance with the standards, requirements, and specifications of the installation of an automatic water-based fire protection system as prescribed by the National Fire Protection Association's NFPA 13 standard for the installation of sprinkler systems, NFPA 13R standard for the installation of sprinkler systems in low-rise residential occupancies, or NFPA 13D, the standard for installation of sprinkler systems in 1 and 2 family dwellings and manufactured homes in accordance with the Uniform Statewide Building Code. According to the National Fire Protection Association, during 2020, residential fires in the United States caused 2,220 civilian fire deaths, 8,600 injuries, and $6.8 billion with a B dollars in direct property damage. In townhomes, the behavior of one resident or one tenant drastically impacts the safety of neighboring families, pets, and property. The requirement for the installation of residential sprinklers in new townhomes was first published in the 2009 International Residential Code and has been retained in every subsequent edition of the Model Code, but is continuously removed from the Virginia Building Code. There was a study conducted in Maryland over a 15-year period from 1992 to 2007 with a total of over 13,000 single-family townhome fires that occurred, with 240 of those protected by fire sprinkler systems. In those 245 incidents, no deaths were recorded and only 6 injuries were reported. There are currently 12 states that have previously adopted this model into their code, and I ask that this committee do so as well.
Thank you, Senator. Questions of the patron?
Yes.
Senator Hackworth.
Do you have a cost of what this is going to cost, the average increase to a townhouse if this goes into effect?
I do not have a cost of what the additional installation would be, but what I would say is that there is no cost that is more costly than someone losing their life.
Okay. Do you know the statistics? If it's the majority of fatalities in fire-related deaths, are they due to the fire or from smoke inhalation?
I'm sorry. Can you repeat that question?
So I'll answer the question. I'm a contractor, and we've had this several times in the past, and statistics show that actually fatalities in fire-related is due to, most of those are due to smoke inhalation, not the fire itself. And so I think that, as a question I ask, is it the deaths more due to the fire or due to the smoke inhalation?
Mr. Chair, I thank the senator for his rhetorical question.
Yes, I answered it for you. The other thing, too, that I would ask
Senator Hackworth.
Thank you. Sorry, Mr. Chair. Does the patron feel that by doing this, it would lessen the awareness, I guess, for fire prevention, and it would give homeowners in these townhouses a sense of false security?
No, Mr. Chair, I would answer the question. No, I don't feel like it would give folks a false sense of security. As a matter of fact, I feel it would do the opposite. It would give them more of a sense of security as far as understanding if there is a fire occurrence, that they would be notified earlier and that they can limit the damage to the fire by having the sprinkler system in the townhomes. And again, we are talking about townhomes, and we are talking about newly constructed townhomes.
Okay, when the time comes, I'd like to speak to the bill. Thank you.
Senator Durant, you were in the queue. Did you have a question? Senator Durant? Okay, thank you. I saw you in the queue earlier. Those in opposition to Senate Bill 525, if you're here, please come up, state your name, organization, concern.
Thank you, Mr. Chair. Erin Corman with the Realtors. While we understand the intent of this bill, we do have concerns about its potential to raise development costs in a time that we're facing a severe housing shortage and the potential increase in housing prices when we have an affordability crisis. So for those reasons, we respectfully oppose this bill. Thank you.
Thank you.
Morning, Mr. Chair. Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association. Our issue with this bill is legislating through legislation as opposed to amending the building code. Virginia has a very robust system for vetting the building code process, and significant discussion took place as we adopted this new code. And this was one of the items that received a lot of discussion, and it was a non-consensus item, so it did not move forward in this current section. So we would ask that we respect the building code process and let that play out. Thank you.
Mr. Chairman, Andrew Clark with the Home Builders Association. I'll echo Mr. Grumbine's remarks about the building code process. This is a building code that we use to build buildings, commercial buildings, residential structures. It's really technical. And I think moving the legislature into designing sprinkler systems, some of the systems referenced in this bill don't even apply to townhome. They're commercial application sprinkler systems. And Chief Johnson can go a lot further than most people can in talking about the benefits and the pros and cons of each system. Our big concern is that we start using the legislature, the building codes becomes a football. One year it's pro-energy, and it just bounces back and forth, and that's not good for our industry. We just want stability, want to know the rules, and move forward. To address a couple of the points were raised, 2 states have adopted this since 2009, Maryland and California. Shocked.
Mr. Clark, how many years has this been submitted for review and study now?
Since 2009.
2009.
And I think a lot of the concern, at least from the industry's perspective, is not so much the cost on the structure. It's a lot of the cost is coming from the land development process where, in some instances, you could probably stick with a 3/4 inch water main, but you're going to have to increase that to 1 inch, and that's significant bump in water connection fees. So in our code discussions, we talked about incentives to reduce street widths and some other ways to kind of alleviate this cost, but this just the legislature doesn't seem like the appropriate venue to dive into things that really are
Thank
fairly
you, Mr.
complex.
Clark.
Thank you.
Appreciate it. Any others in opposition? Those in support of Senate Bill 524, please come up, state your name, organization.
Morning, Chair, members of the committee. Keith Johnson, Fire Chief in Loudoun. I'm here representing the Virginia Fire Chiefs Association as well as Loudoun County. So I'm going to try and address a couple of the questions that were asked rather than, obviously, we're in support. Regarding approximate cost for a 2,000 square foot townhome, again, local option, not mandatory. On the low end, I'm speaking of numbers that have been approved in Loudoun County. It was as low as $2,460 and as high as $3,420, with an average cost around the state of $1.35 a square foot for $2,790. I will offer that the incentives that we spoke about often offset the cost of the installation. It permits the installation from a 2-hour to a 1-hour firewall, which is over a $1,500 savings just in that one aspect. So we feel that the cost is almost neutral when you look at that. Again, New Jersey, add that to the list. They just approved mandatory residential sprinklers because of the fire and the lithium battery fire problem in the United States that's killing our people and impacting our fire service. So New Jersey just passed that mandate, not a local option. I just want to speak real quickly to the board. 2009, as a member of the Board of Housing and Community Development, I'm not representing them, but I'm sit on that voting board. I've been involved in this process for many years. This was sent to a work group where we had extensive conversation, non-consensus as you heard, but during the 2021 code process where we just finished that code process for 2021, the committee voted not to hear testimony on this bill being put forward. So the committee, I feel, was silenced in bringing this forward to the Board of Housing and Community Development. Again, testimony was not allowed to occur during that.
Thank you, Chief.
Thank you.
Others in support?
Good morning, Mr. Chairman and members of the committee. Jerry Maiatico, representing the Virginia Fire Prevention Association, and I want to echo Chief Johnson's statements in support of the bill. To address Mr. Senator Hackworth's question as it relates to what is killing people in a fire, is it the physical flames or the smoke? In fact, it is the smoke. However, a sprinkler system is designed to activate and suppress the fire and control the fire in the incipient stage of that fire. And by nature, by that system performing as designed, it will reduce the amount of smoke production and provide the valuable time needed for the occupants to escape the home, thus saving lives. The bill does just this. It provides the locality the ability to determine if the sprinkler system in a townhome is appropriate based off of their local data, based off of their local fire problem, and based off of the local economic impacts for this type of decision. So we strongly encourage you to support the bill and allow the locality to make a decision to save lives. Thank you.
Thank you very much.
Mr. Chairman, David Westcott on behalf of the City of Chesapeake, we support the bill.
Thank you. Any other questions of the patron? All right. Is there a motion?
Bill.
Senator Hackworth.
Yes. Mr. Chair and Senator Williams-Grave, I appreciate the intent, and we're all here. We want to save lives. I think there's a couple of things, though, I must speak on. One is the infrastructure cost. I think that's a huge thing when you have maybe a 1-inch or 3/4-inch feeder line to a property, and then you have to, the locality says, well, this has to be sprinkled. That could go up to a 4-inch, a 6-inch. That could actually kill the project. The other thing is insurance. I mean, I have spoken to a lot of insurance companies that have said that this would cause a lot of if it malfunctions, if a kid is playing with a ball and hits a head, and or if there is somebody lights a candle or there's something that happens that makes that go off, that literally the insurance cost would be tremendous, and we would all see a raise in the premiums in our insurance to cover this. It also encroaches our personal space. These are continuous pipes that has to go through each of the townhomes to do that. So who's going to take care of the maintenance of that? And also, I think if you get it done for $1.35 a square foot, that would be a bargain. But some of the estimates that we have is $10,000, $12,000, $15,000, because it's not just a one-time cost. You have a maintenance cost. You have a yearly maintenance cost. And, we are in a housing crisis, and I feel like that we have done a really good job with fire prevention and teaching our kids about smoke detectors and proper methods of cooking and safe. Most fires is due to cooking. So I think that when that you do have a sprinkler system, I would disagree and say that a lot of times we look at those as I've got a sprinkler system, so I'll be fine. And so although I do appreciate the patron bringing this, I would ask that the cost, the encroaching on personal space, the infrastructure, the insurance, all the maintenance and things like that would be a reason why that I would not support this bill.
Yeah, thank you, Senator.
Thank you, Mr. Chair.
Yep. Senator Sturtevant.
Thank you, Mr. Chair. Just a brief question. I appreciate what the patron is trying to do from a safety perspective. I assume that we got sprinklers in here that are up in the ceiling. Does this differentiate? Would these be the sprinklers you see in some older hotels that are sticking out of the wall? Or would they be, does the code that we're talking about here and the technology require they be up in the ceiling? I'm just a question about the details.
Senator Williams-Graves.
Thank
Chief.
you, Chair. Answer your question, Senator. The same technology, only one or two activates in a fire. And to Senator Hackworth, these are not commercial systems, not what you see in this building. This does require maintenance annually and upkeep. In these systems, in a residential townhome, these are residential systems. They run off the same plumbing as your toilet and kitchen sink. The same plumbing. They're not separate systems. So there is no technically yearly inspection. There's not a connection for the fire department. They simply activate when there's a fire, a candle that may activate it, and they don't false operate. There are basically no false operations in residential sprinkler systems, only when you need them.
And for the record, that's fresh water supply, just saying. All right, is there a motion? Is there a motion? Senator Rome? Senator, I believe that was a motion to report. All right. All right. We have translation services this morning working well. As a motion to report, is there a second?
Second.
There's a motion and a second to report. All those in favor, cast your vote for, against, or otherwise.
Senator Rome, how do you vote?
I don't know.
Ayes 5, noes 1, 1 abstention.
All right. Senate Bill 524 fails to report. Thank you,
Thank you, Mr. Chair.
Senator Williams-Graves. Next up, Senate Bill 652, Sturtevant.
Thank you, Mr. Chair, members of the committee. This is Senate Bill 652. It is a simple little bill that is permissive in nature, and it simply gives our localities, our Board of Supervisors, City Councils, another tool in their toolbox as the elected bodies to oversee the development and flourishing of our communities. And so what this does is, I know many of you, like me, on the campaign trail or at the grocery store, hear from your constituents about traffic problems, bottlenecks, You hear about a new school opening up and they already have to put trailers out back because the school is already overcrowded. It's something that I suspect no matter where you live, it's a challenge that we hear about and hear about often. Some areas it's going to be more acute of a challenge than others. But that's what this bill seeks to do is permissively, if it's the right decision for a particular locality, they have the authority, and since we're a Dillon Rule state, we've got to give them that authority. This would give them the ability to say, yes, we respect private property rights and the ability to develop, but if there is an instance where traffic is too much of a problem, or if school overcrowding is too much of a problem, or there's issue with sewer and water access, this would give them the common sense ability to be able to say, we're going to press pause on going and putting in a significant development that is going to overcrowd the schools or is going to cause a lot of traffic. And it allows us at the state level, without micromanaging how our communities are developed and appropriately delegating that and allowing our localities to do that. That's what they're elected to do. This just gives them another tool in their toolbox to be able to decide what is right for our communities, as in their role as the elected representatives to do that.
Thank you,
and
Senator.
that is the bill, Mr. Chairman.
Thank you very much. Those in any questions of the patron? Start off, Senator Hackworth. You've been working through your quota. Go ahead.
Mr. Chair, and question for the patron. So let me just get this straight. If I have a lot that is zoned R2 to build residential, and I go to get my permit from the locality, and the locality says, no, I feel like there's too many houses on that street, they can then overrule me and say, you cannot build a house on your lot. Is that correct?
Mr. Chairman, Senator Hackworth, no, that's not correct. As you phrased the question, the locality is saying we have too many houses on that street, we don't want any more houses, would not be permissible. There's got to be a comprehensive plan in place as well as a capital improvement plan, and there have to be specific evaluations from a public use, public safety perspective that have to be identified as reasons to say we're going to press pause on a particular development. So again, it's listed specifically in the bill. Schools, roads, public safety facilities, including fire and police, public sewer and water, water treatment capacity. If the locality determines that those things are inadequate to support the proposed development, as long as they have capital improvement plan and a comprehensive plan that talks about how things will be developed over time, they can say, you absolutely have the right to use your private property as you wish, but we also have these other considerations that we needed to deal with. And that way, we don't have a situation where we're putting the cart before the horse and we're having a major development go in, but we don't yet have the schools, we don't yet have the water and sewer infrastructure, we don't yet have the road infrastructure. This puts things in the right order, or at least permissively allows the locality to put them in the right order.
Thank you, Senator Hackworth, and we also have in the queue Senator Rome and Senator Williams-Graves.
So, yes, Mr. Chair.
Senator Grant afterwards.
At the end of that, they could still say no, correct?
Within the confines of this permissive bill. Under the scenario, Mr. Chairman, under the scenario that you gave me, that you presented, no, they could not say no. But if they're able to identify specific things that are inadequate from a public works and a capital perspective, they would be able to say no.
Senator Rome.
All right. Thank you, Mr. Chair. Are you able to hear me okay?
Somewhat.
Mr. Chairman,
we can read you, so actually we can read you on the screen, so go ahead and we're going to transcribe as we go.
Thank you, Mr. Chairman. Mr. Chairman, I would ask the senator about whether he shares my concerns about unequal application of this law, and that a locality would be able to look at a TIA, for example, a transportation impact analysis, that is nearly identical, but in one case, they would be able to say, well, because this is being generated from a townhouse development to over to use multifamily unit, whatever it is, we're not going to allow it due to inadequate infrastructure. However, an identical TIA result that would have come from single family development, they would be able to call it permissive and say, yes, we're going to allow it, even though the application on this is basically being applied unequally. Does the senator share that concern, and is that addressed in the bill? Because as I look at it, under lines 30 to 32, it seems that that is entirely based arbitrarily as opposed to a uniform standard.
So I did, and I think there's some pretty important components. What the senator has pointed out is sort of the unequal application of this across any number of things. And if there's one component missing, it could prohibit a landowner from pursuing their economic interest, is what I read and transcribed. I think we all have our different interpretations, but that's what I picked up from it. Senator Duran, you're next in the queue.
Thank you, Mr. Chair. This might be more a question for council on this, and I am not a subject matter expert on this type of zoning, but I think that, the Supreme Court has spoken on this issue when it comes to zoning, and if there's I don't know if you would call it a down zoning effort, but
Mr. Chair,
go ahead, counsel.
Mr. Chair, there wouldn't be a down zoning in this situation because this applies to the actual zoning application. If you look on line 31, it says the locality may reject or defer a rezoning application. So it really wouldn't apply in a situation like Senator Hackworth was describing, for example, where they already had their zoning. This is at the zoning process where they're asking for their zoning up front. So there wouldn't be a down zoning situation. It'd be a situation where the locality didn't grant the applied for rezoning up front.
Senator Duran.
apologize. So if you had a situation like Senator Hackworth just described where what was the zoning, was it R2 you said? R2. Would that pose potential legal challenges then if that's been determined and now you have a scenario as the patron has described?
Mr. Chair, as I understand the bill, in Senator Hackworth's scenario, they already have their rezoning, their R2 zoning, so they have a by right to build that house, whatever R2 allows. The law as drafted allows the locality to reject or defer a rezoning application, but in that other scenario, there would be no rezoning application. It would be, subdivision or site plan application.
Thank you, Mr. Chair.
Yep. Any other questions for the patron? Those in opposition to Senate Bill 652, please come up, state name, organization.
Is it the committee's tradition to take opposition before support?
It's the prerogative of the chair, and I've done this on other bills this morning. I'm going to do the same. Opposition first and those in support after.
Mr. Chair, Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association. The arbitrariness of the language gives us a reason to ask to push the pause button and consider this further. Thank you.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia, and there's going to be a lot of people to speak on this, but this is a broad sweeping, almost moratorium in some localities on my industry, building affordable market rate housing, or really anything. This applies to any use. And so for those that think we've got to increase housing supply for folks across the income spectrum, this is the opposite way to go. Localities have a lot of tools available to pay for the cost of infrastructure.
Thank you,
So
Mr. Clark. Next speaker.
Thank you, Mr. Chair. Aaron Corman with the Realtors. We also oppose the bill for the reasons already stated.
Thank you. Next up.
Mr. Chair, members of the committee, Isabel McLean with the Virginia Housing Alliance, and we also oppose the bill for the reasons previously stated. Thank you.
Mr. Chair, members of the committee, Phil Abraham representing the Virginia Association for Commercial Real Estate. I think our concern, and I guess I'd asked Mr. Sharp to comment on this as well, line 24, it says the timing of development of uses otherwise permitted. So I think this bill would apply also to existing uses, and that's one of our real major concerns with this. If a locality has, and this is really what APF is about, people are concerned with zoning that they haven't provided the infrastructure for. So if a locality has gone ahead and rezoned something and then says, well, this use is permitted, but we don't see adequate water and sewer, that's fundamentally unfair and is going to really exacerbate the housing problems in the state. Thank you.
Thank you very much. Those in support of Senate Bill 652, please state your name, where you're from, and your support. And thank you. Yes, sir.
Good morning, Mr. Chair, members of the committee. My name is Kevin Carroll. I am a retired sergeant with the Chester County Police Department, and I serve representing the Matoka District on the Chester County Board of Supervisors, and I speak on behalf of the people in the Matoka District in support of the bill, and this is why. I asked Senator Studeman to carry this legislation because of issues we have with development, quite frankly, in Chesterfield County. Now, look, if you're in the building community, then you know that developers pay.
Sir, real quick, is this an adopted legislative agenda adopted by your Board of Supervisors and your locality?
It's not.
Okay,
Not
thank
yet.
you.
Okay. No, I'm speaking on behalf of my district. Look, we can deny a zoning case right now and get sued for it. I had a huge zoning case in my district, got approved in 1991, 4,500 units. It was supposed to have a high school, a middle school, and 2 elementary schools. They never came out of the ground. I get elected, now we have to buy land and build a high school, a middle school, and 2 elementary schools, which we've already built one, we're working on a second. But yeah, you can deny a zoning case now and get sued in a locality, especially if you articulate that the reason you're denying it is because of insufficient infrastructure. Florida passed legislation to cover this. DeSantis was the governor in 2022 to basically say, look, you have to have adequate public facilities to handle these issues as development comes out of the ground. I believe in every person's individual right to own land, sell it, and improve it, and develop it. But as a locality, we have to be responsible on how we actually supply schools, how we answer to the road and infrastructure issues. And I'm just going to tell you, my district, we've fallen way behind. Asking for a tool to help us with that. Thank you.
Thank you, sir, for coming. All right, Senator Stewart, you want to wrap up?
Mr. Chairman, this is a permissive use. Like we oftentimes hear permissive use bills in this committee. And so, disparate impact and arguments like that, that argument can be made against any bill that is a permissive bill. But again, this is giving, some localities will want to use it, some won't. If this was something that our localities could already do, there would be no objection to it. And so as a Dillon Rule state, it's our obligation to give these localities the tools that they are asking for.
Thank you,
and
Senator.
I'd ask that the committee report the bill.
Move to PBI.
There's a motion to PBI. There's a second. There's a motion and a second to pass by indefinitely. All those in favor, vote on the electronic board. Those opposed, same sign.
Senator Rome, how do you vote? Ayes 12, noes 3.
All right, thank you. Senate Bill 652 fails to report. Senator Van Valkenburg, and we're going to try to work through the last couple of bills here. I know we're a couple minutes.
Ready? Thank you, Mr. Chair. Mr. Chair, Senate Bill 296 is dealing with a part of the code that outlines the process of reviewing and acting on proposed plats, site plans, and plans of development. It is not dealing with zoning. I want to state that up on the top. And so this bill builds on a 2008 bill by former Delegate Glenn Oder, who was here earlier, which created a set of standards for reviewing commercial development projects. And it was designed to streamline the process, ensure localities were able to provide substantive feedback on any major deficiencies, and cut down on the number of back and forth between the developer and the locality, because each time you're going back and forth, you're delaying the project and you're costing everybody, and ultimately the consumer, the person that buys or rents, money. And so this bill would put residential in the same posture as commercial development. And so what would happen is you'd already have zoning, the developer would have their site plan based on the locality's specs, they would submit it to the locality would say, hey, you came up short in A, B, C, and D, and then there would be a back and forth just on A, B, C, and D versus having go-arounds on multiple different areas. I don't want to trespass too much on our time, so I'll stop there.
No, thank you. I see in the fiscal impact, we have many localities that have commented on this bill indicating that they already do something similar. Is that right?
I think the impact statement is pretty telling because it shows that a lot of localities and big ones are already using this process, but also that there is no financial impact on them because they can use the staff that they currently have. I do want to note, maybe I'll preempt Senator Rome's question since we're having a hard time hearing her, but her question was about, what if they get overwhelmed on the front end of the process and they miss something? And I think there's 4 things to say to that. First is this does not, local, state, and federal law would preempt anything, right? So if you miss something that was a violation of local, state, or federal law, you would obviously have to correct that. That's in lines 64 to 74 of the bill. The second thing I'd say is that we've been doing this for commercial development since 2008, and there has not been, it's worked, right? We haven't had balls dropped, we haven't had problems in that space. This would force localities to be a little bit more thorough on the front end, but we know that they can do it because in their impact statement, they said they can do it. And so I'll stop there.
Okay. Any questions of the patron?
Mr. Chair.
Senator Sturtevant.
Mr. Chair, Senator Van Valkenburg, just sort of a clarification question. This would be aligning residential approvals with the way commercial approvals are done?
Correct, on the site plan,
Senator Van
back and
Valkenburg.
forth. Oh, sorry. Yep,
Follow-up question, Mr.
Senator
Chair.
Sturtevant.
Not being a land use person, is this speeding up the residential process or slowing it down, or no difference by aligning it with the commercial process?
Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, I would say it probably has the impact of speeding up, but it does encourage on the front end a thoroughness on both sides, for both sides. The developer, because they want to get rocking on the project, and so they need to develop a thorough plan that addresses all the locality's issues, and a thoroughness on the locality's part because they need to be thoughtful on the front end versus spending months going back and forth with the developers and in the process dragging out the amount of time spent on this approval process and therefore the cost of the project.
Any further questions? Those in opposition to Senate Bill 296, please come up, speak your mind. Seeing no opposition, I presume there's some support in the room, but there's a motion to report and a second. There's a motion and a second to report Senate Bill 296. All in favor, opposed, or otherwise, cast your vote electronically.
Senator Rome, how do you vote? Ayes 13, noes 2.
All right. That bill reports 13-2. Senator Bagby, 595.
Mr. Chair, there's a substitute.
There's a motion on this adopting the substitute. Is there a second? Second. There's a motion second to adopt the substitute. All in favor say aye. Aye. Those opposed? The substitute is before us.
Thank you, Mr. Chair.
Senator Bagby.
Thank you, Mr. Chair. This bill authorizes localities to beginning July 1, 2024, to adopt a healthy community strategy as a part of its its next and any subsequent reviews of the comprehensive plan. It would allow local governments the option of taking a wide variety of environmental, health impacts into account during the comprehensive planning process, including identifying major sources of pollution, air quality, water quality, flooding, and urban heat exposure, access to healthy food, green space, and much more. Mr. Chair, I know there's a couple people here to speak in support.
Senator Bagby, we have some folks here in support of it. We've adopted the substitute before this committee, and so those in support, if we can be brief, we've got one other bill we're going to work through after this one.
Mr. Chair, members of the committee, Ben Hoyne, Virginia Interfaith Power and Light. Thanks to the patron for bringing the bill forward. United States HHS estimates that about 12 million people a year die due to living in an unhealthy environment or working in an unhealthy environment. So this bill would allow, it's permissive, it would allow local governments in their planning process to, as the senator said, to investigate air, water quality, access to green space, proximity pollution, and other things. So really a great a tool in the toolbox for local governments. We've heard from a variety of local governments that would be thrilled to have this bill pass, and so ask for your support. Thank you.
Thank you. Others in support?
Mr. Chairman and members of the committee, Jay Ford with the Chesapeake Bay Foundation. For all of the reasons just mentioned, we support this bill. We also think integrating this information into the comprehensive plan process primes localities to be able to pull down federal dollars. It walks them through a process. There's a lot of EPA environmental justice dollars that are available right now that match up with some of the requirements in this. And so we encourage you all to support this bill. Thank you.
Thank you, Mr. Yes, sir.
Senator Tripp Pollard with the Southern Environmental Law Center. For health, community, funding reasons, all the above, we strongly support this and thank the senator.
Thank you. Those in opposition to Senate Bill 595?
Move to report. Second.
Giving a pause for opposition. There is now a motion to report the substitute and a second. All those in favor, cast your votes on the electronic board. Those opposed and otherwise. Thank you.
Senator Rome, how do you vote?
Protest aye.
Ayes 10, noes 4, 1 abstention.
Senate Bill 595 reports. Senator Diggs, you have Senate Bill 200. It's my understanding you want to carry that bill over to the 2025 session. Is that correct?
That is correct, Mr. Chairman. Thank you.
All right, there's a motion and a second to carry Senate Bill 200 over. All those in favor or otherwise, cast your vote on the electronic board.
Mr. Chairman, is this, what's the motion?
Carry over.
For the year?
For the year. It's 2025.
Senator Rome, how do you vote?
It's a good bill. We should pass it now.
Ayes 13, noes 2.
And Senate, we have Senate Bill 121 still before the committee. Senator Subramanian.
Thank you, Mr. Chair. I'm going to do it up here. So this is SB 121. It's regards to urban tree canopy. Where, as some may know, we're continually losing tree canopy year after year in Virginia. And we've lost, one study showed that over 9,500 acres of urban tree canopy were lost between 2014 and 2018. And the trend is probably going to be shown to be continuing. And so we're going to turn over a new leaf, Mr. Chair, and we're going to try to, the localities, so this basically tries to address the problem by expanding the uses of the funds from some of these ordinances to include preservation and maintenance of trees on public and private land. It gives localities in Planning District 8 who can currently, right now, their ordinances, they can't, they don't have some of the powers that are in this legislation, and to identify and incentivize the protection of mature trees, for instance. And so this came out of an initiative of a 2022 stakeholders advisory group that included home builders, commercial builders, and conservation groups. And we want to also increase the flexibility of local governments regarding how they can use the tree funds.
Senator, real quick, so you're indicating that this has been through a work group, is that right?
That's right.
All right. Those in opposition to Senate Bill 121? Yes, sir. You've drawn some opposition.
Chairman, I understood there was going to be a technical amendment.
Yeah, I was getting there.
And, yeah, I don't oppose the bill with that amendment. Thank you.
Thank you.
Second.
There's a motion and a second on the amendment. Before we adopt it, Jeff, you want to just briefly touch base on it?
Mr. Chairman, I haven't been told of the amendment. I think I know where it's going, but I haven't been told what it is.
All right. Will the patron provide the amendment for the committee's adoption? Anybody?
Yeah. So, Mr. Chair, the amendment, get it up. But essentially, there's percentages that the locality can require.
All right, Senator Suas, we're not going to do essentially this morning. We're going to carry this over to next week.
Sounds good.
Senate Bill 121 will be heard next week. Clerk, does that complete our docket for the day? Committee will rise.